All right. Welcome, everybody. On behalf of the UCLA Alan D. Levy Center for Jewish Studies, I'd like to welcome you to today's program with Tobias Buck as a part of the 1939 Society Program in Holocaust Studies series. I'll be your host today. My name is Jared McBride. I'm an assistant professor in the history department here at UCLA. Our guest today will speak about his recent book, Final Verdict, The Holocaust on Trial in the 21st Century. We will have copies of the book, which you can see here, available for purchase after the event. We hope you can join us for many other Levy Center events this year. You can find information at the back of the room today. I'd also like to thank, as always, the wonderful Levy Center staff for making the arrangements for today's event. Our speaker today, Tobias Buck, is the managing editor of the Financial Times. Born in Germany, he studied law in Berlin before joining the Financial Times as a graduate trainee in 2002. He went on to serve as the Financial Times correspondent in Brussels, Jerusalem, Madrid, and Berlin. His first book, which predates this one, After the Fall, Crisis, Recovery, and the Making of a New Spain, was published in 2019. I'm just going to say a couple words before I turn it over. So each year I teach a large cluster course on political violence to nearly 300 first-year students here at UCLA. One of the 3 case studies in this course is the Holocaust, and each winter I deliver a lecture on justice and the Holocaust, or Holocaust justice. Each year the first slide of that lecture is newspaper headlines from contemporary Holocaust trials, and I update this slide every year. The objective is to show to students that Holocaust justice is still not yet a thing of the past, but rather is still happening around us. My lecture notes each year read, "Trials happening now," in capital letters. Several years ago, one of the headlines I showed students was that of a trial occurring in Germany against a man named Bruno Dey. Dey was a member of the SS who served in the Stutthof concentration camp in what is now Poland. In 2019, the German state charged Dey with 5,230 counts of murder for serving as a watchtower guard in the camp. Only 17 when he joined the SS, Dey was 93 years old when he was charged by the German state. How and why a 17-year-old concentration camp guard, who in Buck's words was not pivotal to anything, not even at Stutthof, so small fish, right, found himself in a Hamburg courtroom in October 2019, facing thousands of counts of murders, is the subject of Tobias Buck's recent book, Final Verdict, The Holocaust on Trial in the 21st Century. The Dey trial is part of a larger story of trials carried out since 2011 by a German state armed with a new legal theory and a sense of urgency to put the Holocaust on trial in a moment when both victims and perpetrators were and are rapidly disappearing. Buck, who attended the trial in person, not only gives the reader a window into the gripping courtroom proceedings of this particular case, but also takes us on an excursion through the author's own family history in the Nazi regime, the history of post-war trials in West Germany, and larger questions about the past and future of Germany's Erinnerungskultur, or memory culture. Throughout the book, Buck tackles big questions about responsibility and justice from both an individual and societal vantage points with deftness and care. The book makes for a gripping and thought-provoking read, and it's the kind of book needed at a time like this as we straddle eras and plunge forward into a future with new threats and challenges. So I once again would like to thank Tobias Buck for coming here to UCLA. Please silence your phones. Thank you.
Thank you, Jared. Thank you so much for coming to my talk today. It's a great pleasure to be in Los Angeles and to have the chance to talk to you about my book. It's obviously difficult, if not impossible, to condense a book into a brief lecture like this one. So there are some aspects that play quite a big part in my book that I won't be touching on in my talk, but that we can perhaps get into in the Q&A and our discussion later on. So I won't be talking about my family history or indeed memory culture, but I will focus on 2 questions that arise from my book. The first is why did Bruno Dey end up in court? Why did this case take place more than 7 decades after the end of the Second World War? And the second question that I would like to tackle is, to me, the most important one, which is, does it make sense? Is it right? Is it just to bring these very old perpetrators to court at this point? So the story started for me in October 2019, when I sat in this very ornate courtroom in the imposing criminal justice building in Hamburg, northern Germany. And this very old man, 93-year-old, was brought into the courtroom in a wheelchair. And he was there to face charges as an accomplice or as an accessory to murder in more than 5,000 cases. And those charges derived from the time he spent as a concentration camp guard at Stutthof, a smaller Nazi concentration camp in present-day Poland. So he had served there as a as a guard from August 1944 to April 1945. He was only 17 when he was first inducted into the SS in August 44. And really, in the decades since, he'd lived a very quiet, very unremarkable life. He had held jobs as a lorry driver, as a janitor, he married, he built a house on the outskirts of Hamburg, he had children and grandchildren, and at no point in these 7 decades did anyone ever consider bringing Bruno Dey to court, even though he had actually on 2 occasions been interviewed by the German police in connection with other Stutthof investigations. But he was always, he wasn't even considered as a small fish. He was just not considered as a potential target for a criminal investigation. But now on this day, in October 2019, he was finally facing justice, 7 decades later. And so as I sat there in the courtroom and listened to the opening exchanges, I found myself transfixed. I had always assumed that Holocaust trials were a thing of the past. Of course, if you think more broadly about the big Nazi or trials examining the crimes of the Nazi regime, Nuremberg, Eichmann, Auschwitz, etc., those had all been done 6, if not 7 decades earlier. I had just assumed that there were in fact no more perpetrators left to prosecute. So to see a man in a dock charged for crimes that were committed in the early 1940s or the mid-1940s just seemed strange and in fact quite anachronistic. So I realized this was a unique opportunity to hear perpetrators and victims of the Holocaust speak just before the last of those voices were going to fall silent. The fact that Dey was a marginal figure never really bothered me. Yes, he stood at the lowest rung of the camp hierarchy, but I soon realized that it was precisely his historical insignificance that interested and unsettled me. It made him, in a profoundly uncomfortable way, more relatable. Like most sane human beings, I could not imagine myself as a murderer or a commander of a concentration camp or a member in an organization of brutes like the SS. Surely, even in a dictatorship, even in wartime, my moral compass would not have failed me so badly. So when we look at images of the Nuremberg trials or the Frankfurt Auschwitz trial, we see a series of men in black and white pictures, and we feel revulsion, but we also feel the consolation of distance. We can tell ourselves that we would never have behaved like them. On this day in Hamburg, however, looking across at the figure of Dey, I wasn't sure I could say the same thing about him. Would I, as a 17-year-old in Nazi Germany, have acted differently? Would I have had the moral courage to climb down from that watchtower, hand over my rifle and say no more? And if I could not be sure, could anyone in the courtroom? I'd come to Hamburg to find a short story on the opening of the trial for my newspaper, but I resolved to return to the hearings as often as I could. I wanted to see how this drama played out, and I wanted to see how the court wrestled with the moral and legal dilemmas thrown up by this case. And I wanted to see in particular how Dey himself understood his role and his responsibility. Surely, if nothing else, he sensed that this was a trial of last opportunities, a last opportunity for victims to tell their story in a court of law, a last opportunity for an old man to confront his guilt and his conscience, and a last opportunity for Germany and its legal system to show that justice would be done no matter how late. The fact is that for much of German post-war history, men like Bruno Dey had little to fear from prosecutors and judges. The country did an appalling job of punishing the perpetrators of the Nazi atrocities in general and the Holocaust in particular. The numbers tell the story. Historians estimate that as many as 250,000 Germans played a role in the Holocaust, or had some responsibility for the Holocaust. And of course, most of the worst perpetrators were dealt with by Allied courts after 1945 or were handed over to Eastern European authorities after 1945, including, of course, famously Rudolf Höss, who was tried and hanged by a Polish in Poland in 1947. The vast majority of cases and culprits, however, was left to West Germany to prosecute. And it failed miserably at the task. West German prosecutors launched investigations into some 170,000 suspects, which is a formidable number, in the years after 1945, but only 6,700 were found guilty and sentenced. The vast majority of those convicted, more than 5,100, received prison sentences of less than 2 years or were simply fined. Of the 6,000 SS members who did service in Auschwitz, only about 80 were sentenced in a German court. And the picture is a little different for Stutthof, the concentration camp that was at the heart of the Bruno Dey trial, where some 3,000 SS personnel did duty. Just 70 of them were put on trial, and most of them in Poland. The reason for this historic failure are quite complex. I mean, there were legal reasons that have to do with some of the peculiarities of German criminal law and the way it had been interpreted historically. There were also political and geopolitical reasons, not least that both Germany and the Allies, including the US, were very keen to secure Germany as a member of the anti-Soviet alliance, and in that context it was deemed to be unhelpful to look too deeply into the past, and it was best just to move forward, not least because some of the men that were used or that could be useful in the fight against the Soviets obviously had quite a dark past themselves. But I think that the main reason why Germany did such a poor job, especially in the early decades after the war, has to do with the social context. So if you think back to, or if you look back at the immediate post-war years, you find a very strange inversion of victimhood in Germany. So Germans looked at their own vast losses, their destroyed cities, the fact that their country was divided, that they'd lost enormous territories. And as strange as it now sounds, they felt themselves to be victims. And what went hand in hand with that perception was the view that whatever evil had befallen Germany and Europe, it was the responsibility only of Hitler and his top henchmen, but not of German society at large. So when it came to prosecuting the guilty in Germany, German courts were only really comfortable with going after two kinds of perpetrators. The first were the aforementioned top Nazi leaders, but they had of course conveniently already been taken care of by the Allies or were dead. And the second class of culprits that did find themselves in German criminal courts after 1949 were the so-called excess perpetrators. So SS men who had behaved with exceptional brutality or sadism, who were typically at the lower end of the Nazi hierarchy. The ones with more functional responsibility, who typically had university degrees and doctorates and were already quite well integrated into West German society, the so-called Schreibtischtäter or desk perpetrators, had much less to fear. And the other group that was left largely undisturbed were men like Bruno Dey himself, so the helpers and facilitators, the ones who kept the trains running, who kept the books, who oversaw the deportations, the camp guards and the soldiers. They were protected not least by German jurisprudence in the rare cases that did go to court, notably the Frankfurt-Auschwitz trial in the early 1960s. What emerged from those trials was a legal requirement, or perhaps I should say a perception of a legal requirement, that meant that a perpetrator had to be shown to have committed a specific act of killing in a specific time and a specific place. Now, in a normal murder trial, that makes all the sense in the world. But in the context of the Holocaust, the requirement to show that concentration camp A had killed inmate B and C at a certain time and a certain place was, of course, almost impossible to meet in the context of the sort of anonymized, industrialized manner of killing. So starting in the 1970s, the already desperately slow stream of prosecutions reduced to a trickle. In 1984, less than 4 decades after the end of the war, with thousands of potential suspects still only in their 60s and 70s, just one Nazi case was brought before a West German court. There was not a single conviction. In the 2 decades that followed, prosecutors and courts managed to achieve a grand total of 33 trials and 18 convictions. So what changed? How did Bruno Dey find himself in court? I found an answer to those questions in a small town in the south of Germany, in the house of a retired judge called Thomas Walter. Walter had retired from his role as a district judge in 2006 and had decided that he still wanted to spend a few years working on legal affairs. So he joined a little-known German authority called the Zentrale Stelle, or the Central Office for the Investigation of National Socialist Crimes. This was, and still is, the body still exists, a quasi-prosecutorial organization that examined Nazi crimes, tried to establish the identity of suspects, and then passed on their dossiers to the responsible prosecutors for further investigation. At the time of Walter's arrival in 2006, it was a largely dormant authority. The challenges of prosecuting Nazi criminals were obvious, but he decided to challenge those legal orthodoxies head-on. So the theory he developed was to treat the entire concentration camp as a crime. So he argued that that it wasn't necessary to show that a perpetrator was connected to an individual specific killing. He said, or he argued, that the concentration camp should be treated like a factory of death, in which anyone and everyone who helps keep that factory running is responsible, at least as an accessory or as a helper. And he decided to try out his theory in the case of possibly the most prominent Holocaust perpetrator or suspect still available, John Demjanjuk, who, as you might remember, was sentenced to death by an Israeli court in the 1980s for his alleged role as a camp guard in Treblinka. It turned out, however, to be a case of mistaken identity. Demjanjuk had been a camp guard, but not at Treblinka, but at Sobibor. His conviction was quashed and he was handed back to the US, where he had lived after the war. Walter urged his extradition to Germany, which the Americans were in the process of pursuing anyway. And he built a case, convinced Munich prosecutors to take it on, and Demjanjuk was indeed put on trial on the basis of his theory that even though no one could prove a direct link between Demjanjuk and any individual murder, his mere role as a camp guard was enough to convict him as an accessory. The Munich court agreed, and in a landmark judgment in 2011, Demjanjuk was sentenced to 5 years in prison. It was a late acknowledgement, too late for all but a handful of cases, that German justice had gotten this terribly wrong. In the case of Bruno Dey and a few others, however, it was not too late. So Dey's alleged crime, to be clear, was his presence at the camp, his role as a camp guard. At no point did prosecutors allege that he himself committed a murder or that he took an active part in the killing. But his presence as a guard had obviously served to deter the desperate prisoners down below from attempting to flee. No guards, no camp, no gas chamber, no killing. That Dey himself struggled to understand his individual culpability made no difference. His only argument over the course of the trial was, in fact, that he had no choice, that there was no opportunity for him to leave the camp. And while that is a superficially, not entirely unconvincing argument, the prosecutors were able to prove through historical expertise, etc., that in fact it had been possible to leave, for an SS man to leave a concentration camp. And while it was difficult, it was not impossible. Leaving the camp meant joining the German armed forces and would almost certainly mean fighting in the sort of desperate battle on the Eastern Front. That this was not a particularly easy or attractive option is obvious, but what mattered legally was that there was an option. So the case obviously raised difficult questions, not the least of which is it right to go after lowly camp guards when many of the men higher up the chain of command had escaped with minor punishments, if they were punished at all? This was a legitimate question, but in the legal sense, it was not hard to answer. In Germany, as in most countries, murder does not fall under the statute of limitations. If you kill a person, or you help kill a person, you can and will be prosecuted in a German court, even 50, 60, or 70 years after the act. This was well-established case law when it came to common murder, the proverbial jealous husband killing his wife, the bank robbery gone wrong, etc. If it was right in those cases, how could it not be applied to the Holocaust? And the fact that German courts had treated Nazi criminals with unfathomable leniency in the early decades after the war simply could not mean that courts today should follow the same path. To me, however, there were at least two further reasons why I thought it was right to bring Bruno Dey to trial. The first had to do with the victims of Stutthof. Over the course of the 9-month trial, the court heard vital testimony, often in person, from some of the survivors of Stutthof. So these were very old, very frail people who travelled to Hamburg from Poland and France and Israel, or who testified via video link, including from Australia. The significance of their testimonies was beyond doubt, although they made for unusual witnesses. None of them could identify Bruno Dey. None of them remembered seeing him at the camp, or could personally tie him to any act committed there. What they did instead was to paint a picture of the conditions they were held in, of their daily lives, of the deaths of their loved ones, and of the way the SS men ran the camp. They attested, for example, to the fact that the existence of the gas chamber, something that Dey at certain points said he wasn't even sure he was aware of at the time. The survivors made clear that even they, after a few days at the camp, were perfectly aware of the gas chamber and its function. It was common knowledge. And they confirmed in their own way the legal theory developed by Walter in the Demjanjuk case. The camp was not a prison or detention facility in which killings took place. Killing people was the purpose of the camp. You had to be extraordinarily lucky, not once or twice, but over and over again, to survive Stutthof, especially in late 1944 when a typhoid epidemic swept the camp and the SS decided to leave thousands of prisoners to die. Stutthof too was a factory of death, and everyone who helped keep that factory running contributed to those deaths. Seeing these witnesses speak in court was a poignant and moving experience for us as spectators, but also for them personally. It was striking how much significance they attached to their moment in court. One of them told me simply, "This is the most important thing that I've done in my life." To understand that sentiment, you have to understand the utter sense of impotence that the prisoners in a concentration camp felt. Their life was worth nothing. They could be killed at any moment for any reason, or no reason at all, by the lowliest of SS men. The fear never left them. Eva Pusztai-Fahidi, a survivor of Auschwitz who testified in another of these late Holocaust trials, explained this to me in the following words. "They were gods in the world. One of them actually said this, I later read. He said, 'Above me is only God.' And it really was like that. You cannot imagine the power these people had. They could do whatever they wanted. There were no limits. I knew that he," the accused in her case, "had behaved and felt like God. I had to be so afraid of people like him. And it is terrible to have such fear every second of the day. That I could now speak against him in a court of law, that was simply miraculous." I said there was one other reason why I thought it was right to have this trial, and is perhaps the most important one. I thought and still believe that prosecuting the Bruno Deys is relevant to our world today. We have, I think, more to learn from trials against the small-time helpers than against the murderous masterminds. As I mentioned earlier, it was precisely the relative insignificance of Dey that drew me to this case. The charges brought by the prosecution alleged that Bruno Dey played a small part, in a great evil. If he was found guilty, his guilt would be minuscule in comparison to that of Hitler, Himmler, Heydrich and the others. But Hitler, Himmler, Heydrich and the others could not have made the Holocaust reality if it had not been for the hundreds of thousands of Germans who helped. The Holocaust was many things, but it was also the work of hundreds of thousands of Germans who simply followed orders and did their part. They compiled the deportation lists, shipped the poison gas, rolled out the barbed wire, steered the trains, cooked the executioners' meals, kept the books, and guarded the perimeters of Stutthof, Auschwitz, and Treblinka. What made them say yes? Or better, what stopped them from saying no? This was a question that felt burningly relevant the day I sat in the courtroom and made my decision to write this book. Despite the frequency with which we invoke comparisons with Hitler, there is a uniquely monstrous quality. It creates distance, as I said before. The traits and weaknesses at the other end of the chain of command, however, the ones that we see in men like Dey, I think we recognize them everywhere, all the time, and even in ourselves. This was summed up with stark precision by Anne-Marie Göring, the presiding judge, in her truly remarkable verdict in the case. She said, "Thousands, hundreds of thousands, even millions of perfectly normal people in Germany did this to perfectly normal people, thousands, hundreds of thousands, millions of Jews, Poles, Lithuanians, Hungarians, Russians, and dissidents. Just like that. Out of indifference, out of a sense of duty, because of an order, because of an individual and collective failure of conscience." It's an interesting catalogue of guilt, isn't it? Indifference, duty, order, failure of conscience. It's interesting because it doesn't include the behaviors, ideologies, and pathologies that we normally associate with the perpetrators of the Holocaust. Hatred, anti-Semitism, racism, fascism. The judge concluded, and I would agree, that in the case of Dey, these were not what motivated him to stay, what kept him on that watchtower. Instead, the term she used to describe his behavior, and which echoes a term that was brought up in another of these late Holocaust trials, is the German phrase, die Bequemlichkeit des Gehorsams, the comfort of obedience. It describes with painful accuracy the attitude of countless Germans during the Nazi period. But I always thought there was a ring of universal truth to them. Of course, there's comfort in following orders and directions, in not having to think for yourself, in passing responsibility up the ranks. That is true today, even for those of us lucky enough to live in liberal democracies governed by the rule of law. And it was undoubtedly true for Germans living in Nazi Germany and those who served in Auschwitz, Treblinka, and Bergen-Belsen. I didn't take the reference to the comfort of obedience as an attempt to excuse the deeds that Dey was on trial for, but it was valuable. It offered one of the most succinct explanations of German behavior under the Nazis I had heard to that date. The phrase captures something important about the culpability of the guards and clerks, the junior bureaucrats and ordinary soldiers involved in the Nazi genocide. Many of them would, had they served another nation in war, never have dreamed of aiding and committing the kind of crimes that took place under the Nazis. For many of them, however, taking part, going along, not objecting, seemed like an easier, more comfortable and less risky choice to make. More comfortable even than simply walking away. I'm going to quote another passage from the presiding judge, Anna Göring's verdict. The decisive questions raised by this trial were, what crimes against humanity are humans capable of? And what brings people to commit cruelties like those at Stutthof, or to take part in them? Because it is only from the answers to these questions that we as humans can learn for the future. That is why the warning is not, don't allow another Nazi killing machine. It is rather, and that was shown also in this trial and especially in the personality of the defendant, resist the beginnings when people are being degraded, excluded, humiliated and deprived of their rights. Resist the beginnings when racism and injustice become acceptable in society. Don't look away, but take note when people are robbed of their dignity. Be compassionate and be mindful of your own indifference, your selfishness, your comfort of obedience, and your ability to live with injustice. Think for yourself and question what you're being asked to do. Don't obey orders when they call for inhumanity, injustice, and murder. Respect human dignity at all cost. And yes, even when that cost is your own safety. That is the message of this trial. Only then can you say, I have not made myself guilty. It's a pretty remarkable passage for a criminal judge to issue in a court of law, I thought. And obviously, this is a very hard imperative to follow, especially for a young man like Dey. This was clear to the judge too. She continued, "Of course this is asking a lot, especially from someone who was only 17 or 18 at the time like yourself, had I. And of course none of us knows how we would have behaved if we had been in your place. But precisely because of that, the message has to be, whoever behaves like the accused Dey is guilty and has to answer for it until the end of his life. That is the just response to the unjust Nazi state and the crimes against humanity committed by human beings under this regime." I wanted to give you these quotes in full because I think they provide ultimately the most powerful answer to the fundamental question hanging over this trial and that of other late Holocaust perpetrators. Why prosecute a handful of old men at the very end of their life for their involvement, often quite minor involvement, in the crime of the Holocaust? Because the message that these trials send is important, that there must not be impunity, that the Holocaust took place, and to say this clearly in a court of law at a time when Holocaust denial is once again on the rise. And perhaps most importantly, that we today must be conscious of the behaviours, weaknesses, and the failures that allow such crimes to be committed. We too know the pressure to conform, the reluctance to stand out, the fear of ostracism, and the comfort of obedience. We too succumb to them at times. The consequences and costs of our moral failures today are obviously different. The stakes are lower. Not many see their moral fibre tested in the way that Bruno Dey's was in the last months of the Second World War. But that should not blind us to the fact that our human frailties are always and forever the same. What changes are the times and circumstances in which those frailties are exposed. Of course, Bruno Dey was not just unlucky to find himself at Stutthof in 1944 and in a Hamburg court in October 2019. His failure to make the right choice all those years ago was a genuine failure. More than that, it was a crime. But his story is weighted with moral luck and the absence of such moral luck all the same. Had he lived in a different time and a different place, his obedience, his weakness, his inability to say no would have carried less weight. Had he been born like I was in democratic Germany in 1975, would he have become an accomplice to murder? The answer almost certainly is no. To say so is not to minimize his responsibility or to minimize his guilt. It's a warning. If he could become an accomplice to murder, which of us cannot? Thank you.
We'll get it going. Okay.
I was wondering, for 70 years or for 7 decades he went unnoticed. What brought notice to him that finally led to his arrest?
Yes. So following the Demjanjuk judgment in 2011, there was a big push, both in the central office, this centralized body that examined and looked after potential Holocaust perpetrators, but also in individual state prosecutors' offices across Germany. And there was a coordinated attempt to go after all the available information of even lowly camp guards who previously had been excluded from their interest. And so they basically went over information that had been available all these years, but with a renewed sense of vigor and with the knowledge that the recent judgments would mean that they could actually be put on trial and there was a decent chance of them being convicted. And so in the case of Dey, there was only one piece of evidence. So there was a receipt from, I think, the 8th of August 1944, where he signs a receipt for his SS uniform at Stutthof. And that was the only piece of evidence they had. They were then able to establish that this man was still alive, where he lived, and that was all they needed. And then there were many, many complications. He was at some point deemed to be unfit to stand trial because of his age, but ultimately, yes, that's what led to his charges. What else?
Yes, thank you for your presentation. I'm curious, who is this for? Who are these trials for? I'm not really clear that the descendants of people who are harmed by this violence benefit from these trials, and I'm not really sure what they do for the public either, so that's my question. And it's kind of connected to a larger question I have about the role of law in adjudicating harms of the past. So I'm reading these Holocaust trials as part of a retribution for harm that people caused, maybe a calling for justice, but that is distinct from healing. And so I'd love to hear you describe more about who you think these are for. Because to me, I read the trials as for the German public, right? They're not for any healing for the Jewish diasporic victims. And that makes me wonder also, are these trials part of a performance of German Holocaust memory? Are these trials part of a presentation of this Vergangenheitsbewältigung that I also see your work as part of, this performance of guilt that is kind of actually disconnected from the healing that's necessary? So I'd love to understand the trials that are happening now. What do they actually do for society?
Oof, okay. I'll try and answer the question as best I can, but it's obviously a very complex one. So, who are the trials for? A trial doesn't have to be for anyone or anything. I mean, the nature of criminal law is that if a crime is committed, the state will try and punish the perpetrator. So...
But why?
But why? Well, I mean, you could ask the same question for every criminal trial everywhere.
And I do.
Okay, well, I mean, there's obviously a huge body of academic literature around what is the purpose of crime and punishment. And just to run through a few of those concepts, I mean, the most basic one is prevention. So by punishing the guilty, we, prevent the guilty from doing this again because they're locked away for a certain period of time. But more importantly, there's the idea of general prevention. So obviously, if you see that someone is being punished for a misdeed, you yourself are disincentivized from committing the same deed. So that's prevention. And then beyond that, I think for a society to function in a remotely harmonious way, it is important that the laws and the rules that we have agreed on that govern our Commonwealth are reaffirmed and upheld in court. If we as a society, well, every society for tens of thousands of years has decided that murder is a taboo, that this is not something that we should be doing. So if that is the rule that we all live by, then obviously someone who violates that rule has to be punished. There have to be consequences for that. And then, I mean, there are various other ways we can think about this. I mean, the idea of balance, I think, is important, that a crime puts something out of balance, and that a criminal trial and the aim to prosecute and punish the guilty does something to restore that balance. I think it's a very difficult concept to get your head around in the case of the Holocaust, obviously, because how could any trial, let alone the trial of such a small-time perpetrator, do anything to restore balance? But I think I disagree with you that it does nothing for the survivors or for their families. I mean, my observation from attending this trial, from speaking to the survivors who appeared there as witnesses, was that it mattered enormously to them. Now, I mean, one has to keep this in perspective. There's never a happy end to the Holocaust. There's no cathartic or redemptive moment in these trials. But I made two observations about this. The first was the one that I mentioned earlier, that the ability to help bring one of the perpetrators of the Holocaust to trial did something for the survivors in terms of, I'm searching for the right word, but it's obviously much more significant to get back at them. But I think it helped them. It helped them address this feeling of existential impotence that they had during their time at the concentration camp. And then finally, I think why this mattered enormously to the survivors was that it allowed them to talk about their lost families. And it was very, very noticeable how the survivors in their testimonies were keen to name them. So they would talk about, my cousin so-and-so with her baby and my mother. And I think, again, there's nothing cathartic about that, but I think it helped them to reconnect with their loved ones in a meaningful way. So I think I do think I disagree with you on that. I think it did a lot for the survivors and their families in this particular case. I mean, there were like 5 other questions, but I maybe.
Yeah, the part was about the performance element of what does this do for the German public, and how is this part of the larger practice of Vergangenheitsbewältigung?
Yeah. So just to explain, the Vergangenheitsbewältigung is the German term for coming to terms with the past, and is the sort of phrase that hangs over everything that Germany has tried to do to come to terms with its past, with its Nazi past. I mean, there's a whole chapter in my book about German memory culture, and I share some of the critique of it, that there is something performative about it, that it has become in some ways an empty ritual, and I also think that this was actually a point made by the defense, by Bruno Dey's lawyers, is that are you actually trying to put a guilty man on trial here, or are you trying to compensate for the failures of German justice in the decades after the war? And I wish that failure hadn't happened. I wish Germany had done a lot more in the years after the war, when they could have gone for much more serious perpetrators than Bruno Dey. I also wish that Dey himself had been given the opportunity to stand trial in the 60s or 70s, when he was, I think, when he would have been in a far better state to engage with the accusations and perhaps draw some lessons from them. But I think just because Germany failed at this in the decades after the war doesn't make these trials purely performative. I don't think that's the case. I think this is the right way. I think what happened in Demjanjuk and the trial since, that is the way Germany should have dealt with Holocaust perpetrators. So I don't think it's performative, no.
I'm going to jump in here on a similar point and maybe kind of just drill down on this a little further. So in talking about memory culture, and you do in this chapter in the book really kind of sketch out a broader history of it, how it came into being, debates about it, and where we're at. And you also kind of make the point in the way in which Germans embracing their past or trying to overcome their past has become, in your words, a unique selling point for Germany. And then you use this interesting metaphor about it being kind of a national brand, right? Like a luxury car that they can sell the world. This is the country that has embraced its evils. Look at how wonderful we are. And I guess my question, because when you read a book like yours and when you dig into the history of these trials, the incongruity between the celebratory memory culture with just, a baffling history of justice or lack of justice, similar to this question, but how did those things manage to stay on separate planes? Like, did you have a theory of that? Like, how did an entire generation of Germans, let alone, Americans are shocked to hear of the shortcomings of German justice because we're so enamored with the successful memory culture. So it's still a successful trope in the West, but how did these things manage to stay uncontaminated from one another? And I'm just kind of curious if you had any deeper thoughts on that. Yeah.
So I think it's important to remember that the German memory culture, as we now know it, and as it has emerged as this part of brand Germany, and I don't want to be too snooty about it because it is. We are criticizing at a pretty high level. It is very difficult for a country to engage honestly and frankly with the crimes of its past. And I don't think many countries have done it. There's not many countries that have as dark a history as Germany as well. But I think it's important to remember that this German memory culture really only emerged after the 1960s. So I think the problem was that actually there wasn't really a contrast between the way Germany dealt with the Holocaust legally and socially and culturally in the first 2 decades after the war. So there was denial, there was a desire to draw a line under this, there was a desire to pass responsibility up the chain of command. And I think by the time that Germans, in part as a reaction to the Frankfurt Auschwitz trial, but also in reaction, and Eichmann, of course, but then much later on, also in reaction to, frankly, popular culture. So, the TV series Holocaust is universally cited as a major factor in Germany starting to engage with the Holocaust in a more serious way, and then later on Schindler's List as well. So but by the time this happened, the door to a more vigorous legal prosecution had sort of closed. That would be perhaps a slightly flattering explanation for Germany. The other truth is that again, I do not want to diminish what Germany and its fairly unique memory culture have achieved and the benefits it has brought, I suppose. But it is also much easier to build monuments, to have prizes, to politically support Israel. These are all parts of German memory culture. This is all much easier than actually putting your brothers, your fathers, your uncles on trial and sending them to prison. So, yeah.
Okay. Other hands.
I have a kind of related question, actually, maybe to drill down into you were talking about the early social context. You mentioned German jurisprudence, and I thought you said German Jewish prudence.
Oh.
And it made me think of, I was just at the Jewish Museum in Berlin, and there's this wonderful exhibit of photographs of the German Jewish community in the 1960s, and kind of the whole point was oh wait, they're still here. But the reason I think my mind did that was that it makes a certain amount of sense to me that German Jews might find it prudent not to push for certain types of prosecutions. So I'm wondering how, Jews, if at all, factored into that social context and how their demands, their premises, their, sense of what they had to lose or gain from this, changing approach to prosecution evolved over that period.
Okay, well, I this gives me a chance to mention one of the most interesting figures, I think, in post-war Germany, who's rightly become more and more celebrated. There's actually a new English language biography out about him, Fritz Bauer, who was a Jewish social democrat, persecuted by the Nazis. He was actually interned in a concentration camp in the early 30s, and then managed to flee to Sweden, and after the end of the war returned to Germany and became one of the most senior prosecutors in the country. He was the man who spearheaded the Auschwitz trial in Frankfurt. He was also the man who gave away the identity and the location of Adolf Eichmann to the Mossad. So he was the person who tipped the Israelis off about his presence. So he was a formidable, truly impressive character who really single-handedly tried to put the Holocaust on trial in Germany by launching this sprawling Auschwitz trial. And his goal was not just to find individual culprits. He selected an array of figures from the deputy camp commander all the way down to the lowliest barracks leader. And he wanted to basically put on trial the structure and system of the concentration camps. And he succeeded. It was a hugely influential trial. It unfortunately, through rather complicated legal machinations, ended up playing a major role in setting the bar for future prosecutions very, very high. But so here is the rare case of a German Jewish public figure after the war deciding to stay in Germany and to continue their service for German democracy and leading this immensely important trial. Now, interestingly, he himself never appeared in court. He thought that Germany might be ready for an Auschwitz trial, but he didn't think Germany was ready to have a Jew leading the prosecution. So he picked 3 young prosecutors, all of whom had served for Germany in the Second World War, and they were the ones who did the pleading in court. So a hugely ambivalent story, frankly. But he is a great exception. I mean, the German Jewish community was tiny until the collapse of the Soviet Union, and lived a very parallel life. There were very few prominent Jews in West Germany in the 50s, 60s, and 70s. And it's a very interesting question. I don't think I've read a lot about the Frankfurt Auschwitz trial, but I'm not sure I've read an analysis of how the Jewish community followed this trial. I'm sure with huge interest. But I think the overwhelming sense at the time was, in a weird sense still, that as a Jew in Germany, it was best to kind of keep your head below the parapet. So, yeah, I'm not sure that answers your question, but I did want to talk about Fritz Bauer briefly, because I think he's in.
Yeah, I was wondering, how many Germans were given pardons after World War? Like, we've read a lot about Operation Paperclip with people like Werner von Braun, over. How many were, and did those likely ever come out, or did they ever?
There were multiple rounds of amnesties. So they were initially directed at lesser crimes committed during the Nazi period, where there were blanket amnesties in the early 50s, and then there was a very controversial amnesty that was in fact signed off by, my history escapes me. Was it General McCloy, the American general? McCloy. Anyway,
I'm blanking. Oh,
somewhere in the book. Anyway,
yeah.
There was an amnesty for even many of the worst perpetrators of the Holocaust who were in McCloy, okay, my memory hasn't escaped me entirely, who were held by the US in a German prison at Landsberg in Bavaria. So this was really the sort of top tier of Nazis, many of whom had received death sentences, but were still waiting for those to be carried out. And in the early 50s, as part of, under intense German pressure, but also as part of this effort to basically secure Germany for the Western Alliance, McCloy signed, some of the death sentences were carried out, but many were commuted, and many of the inmates there were ultimately pardoned. And so this led to the very strange and unsatisfactory situation that because of this pardon, some of the worst perpetrators, i.e. who were facing a death sentences, were released after 6, 7 or 8 years in prison. And those down the chain of command would potentially get sentences worse than that. So yes, there was a whole campaign at numerous levels, at the individual level, at the collective level, by the German Parliament and by US and Allied authorities to pardon German war criminals.
And how many of this gentleman's superiors were ever tried? Any of them?
Yes. So interestingly, the commandant of Stutthof is the only Nazi concentration camp commandant who was ever tried in a German court of law. So many of them were killed or were sentenced in that period, 45 to 49. He managed to kind of stay undercover until 49 and was then put on trial in the 1950s. He'd fled to Switzerland and then returned. And he is, I have quite a long passage about this in my book. He is one of the examples of a really senior, high-ranking Nazi, the commandant of a concentration camp, who was also treated as a mere accessory to the crime. So even though he oversaw the camp for several years, tens of thousands of inmates died on his watch. He was treated not as a perpetrator, but as a mere accessory, as was Bruno Dey. But in Bruno Dey's case, there was, of course, a strong logic to this. How you could treat the guy at the top of the camp as a mere helper is, of course, bewildering. So yes, he was tried, and I think he received a sentence of around 8 years or so. There was an appeal, but so he spent some years in prison, but not that much.
Was the trial on jury crime trials for this young?
No, so German criminal trials. So Germany doesn't have jury trials. It was a senior judge and 2 junior judges who oversaw this. And so actually this is one of the interesting distinctions between a German criminal trial and a US criminal trial. So there's no jury, there is the judge basically runs the whole trial. There's the role of the lawyer and prosecutor is much diminished compared to the US system. And this is, this can make for a fairly quiet, staid kind of criminal trial. There are, unsurprisingly, not nearly as many German television series about lawyers and trials because it's usually quite boring. But this trial, at least for me, was a big exception.
My second question is, we heard stories in the 60s, probably early 70s, that the new generation started to question their fathers and their grandparents, for instance, of what they've done. And was that at all a collective sort of, what's the word, guilt that they gave to the older generation of what is it that you've done, and why are we not punishing you guys and your perpetrators?
Yes, I mean this is one of the defining stories of post-war Germany, is the confrontation between the post-war generation and their parents, and this question, what did you do in the war, is the quintessential German question. I have a chapter in my book about my own family history, which I put in there not because it's so exceptional, but just because virtually every German family has an SS man or a Wehrmacht officer or something in their family, and there's actually the German Federal Archive has its own, which hosts the archive of the membership lists of the Nazi Party. They have a website that simply says "War Opa ein Nazi?" Was Grandpa a Nazi? And you can go and type in your grandfather's name, and it spits out whether they were a member of the Nazi Party or not. So, sorry, I'm getting slightly diverted from your question, but it is an absolutely seminal, quintessential moment in post-war German history, starting in the 60s, in part under the impression of the Auschwitz trial, of the Eichmann trial, but in part also due to the coming of age of the post-war generation, that this confrontation takes place. Obviously not everywhere, and not everywhere with the same intensity, but it goes hand in hand, I think, with the creation and the development of this particular German memory culture, where the Holocaust and the Nazi period becomes something that is defining for Germany and for German identity.
So I'll round us out here with one final question, hopefully not too depressing before we leave today. So if we kind of, in thinking about, as a historian in me, about periodizing these trials, and we know 2011, and then whenever they end, you went into this courtroom, write this book about one of the last trials, but we might presumably have, there are a couple ongoing.
So I think so. There were two more after this trial. Right. I'm not aware of any that have happened since.
Since then, okay. So whatever periodization we have, whether it's 2011 to 2025 or 2030, but if in the future when we look back at this time period, this is also, perhaps unfair to the German state of prosecutors looking to, carry out these trials with whatever good intentions that they may have. But this is also obviously overlapping a period of the rise of the far right, not just in Germany, but in the larger West, right? And the question here is, this is kind of hard and maybe unfair for you to say, and perhaps a little bit depressing, but are we going to look back at this period of these last gasp efforts of these trials, however well-intentioned, with whatever utility was intended for them, and perhaps, see an interesting missed moment, or perhaps the lessons of a Bruno Dey just following orders, that we might be seeing the rise of similar such individuals in the current moment. So maybe not asking you to prognosticate, but just something to round us out here. So.
It was interesting to me that this trial took place at a really strange and unsettling moment for Germany. So literally a week before the trial opened, there was a terrorist attack on a synagogue in Halle that on Yom Kippur, in fact, where by a miracle the attacker, who was a German neo-Nazi, couldn't break down the wooden door, but there were 51 people inside. And had he was armed to the teeth, had he been able to break through that door, it would have been an absolute massacre and the worst atrocity in post-war German history. And there were many, well, not many, but there was a spike in far-right violence against immigrants, against Jewish institutions that coincided with this trial. And this was referenced constantly during the trial. And I think it gave, at least to the judge and to the prosecutors, a real sense of purpose. And they said, this is the way, or one way, to try and confront this rise in far right sentiment and far right violence is to hold these kind of trials. This is the response of a state in which the rule of law still holds. And at the same time, of course, this was the period in which the German far-right party, the Alternative for Germany, had a huge surge, and it hasn't gone away since. It's only grown and grown. And at the moment, we have, in some polls they're close to 30%. So it's a really unsettling time. It is clear that the German far-right wants to challenge the imperfect, but still, in some ways, quite important German memory culture. They do not want Germany and German society and German politics to focus as strongly as it has done on the crimes of the Holocaust. They want Germany they want Germans to look at their history, at the glorious chapters of German history, whatever they are, and so, I'm afraid I have to concur. We might well look back at this as perhaps not something of a high watermark, but certainly as a moment that will not be repeated for many reasons, and not just because there will no longer be any perpetrators around to prosecute. It's a rather somber thing on which to end this discussion, but it is clearly something we have to worry about.
Yeah, indeed. All right, thank you everyone for joining us. Thanks for the conversation, and thank you to Tobias Buck.